Hello, I'm Gabriela Vega. Every week, the law firm where I work, Adair Thurston, brings you great programs about the pressing legal issues you may be facing. Today, I'm here with my colleague, Lisa Ward. Hi, Lisa.
Hi, Gabriela. Good to see you again on Wednesday.
Winning Wednesday,
That's right.
Our favorite time. Lisa is an excellent attorney with years of experience in various areas. She works in areas business, corporate formation, industrial hemp law, and estate planning. Lisa is a wealth of knowledge.
Thank you.
You're welcome, darling. It's only true, darling. I'm really excited to ask you today questions about why people should plan for the future, why people should consider different legal vehicles, legal documents. Today, you guys, we're also going to be talking about the ways that we can protect our property with these types of legal documents.
Right.
This is what the legal topic estate planning tries to help people accomplish. Lisa, are you ready?
I am ready. This is my favorite area to explain because I think I came into the practice of law without an adequate enough information to even help my family in this area. And after a number of years of practicing, I feel very equipped to help with that. So question, do we know what happens if you don't do anything?
I think I
put
know.
you on the spot.
I think I know, but do you guys know? That's the question.
Right. So if you procrastinate, and I am a procrastinator, and do nothing, then the law does provide some protections. Okay. And it just might not be the protections you're looking for. For instance, if you do not have a will, you don't have beneficiaries on your assets, you don't have a trust, and you pass away, the law will provide your spouse will get half if you also have one or more children. Did you know that?
I didn't. I know there's something called intestacy law, right?
Yes,
but I didn't know how exactly it worked.
So most people don't expect that, right? So the only things that would pass outside of that would be something that you and your spouse have titled together.
Oh, okay.
And of course, we know plenty of families that the parents aren't necessarily married. So then the question becomes, well, what happens in that situation? And if they aren't holding themselves out to be a common law marriage, right, which has its own particular set of criteria, then the children would be receiving everything that is in that person's name. And that's not always what we want. And they would be receiving it at 18.
Oh, wow.
Which is also something for those of us who have, young adults that we may or may not think is an appropriate time to pass well. So that's something that we look at by having a will, a trust, or beneficiaries. We can avoid those uncertainties.
Well, and Lisa, that leads to a really, I think, important question. I think that people often think that only the very wealthy and the very old need to concern themselves with estate planning. Right. Tell everyone why that's inaccurate.
Yeah, completely inaccurate. For one thing, if you have children, in your will, you can state who you would like the guardian to be in the event both parents pass away. So automatically, it would defer to the remaining living parent. But in a common accident, which can happen as likely in our 20s as in our 80s, and the unfortunate event both parents would pass, then we want to know who that should be and avoid a legal argument. And the person that's best suited to raise the kids might not be the best person to handle the money available for the kids, right?
Right.
We all have our gifts.
Absolutely.
And we should be able, in our documents, to identify who we think that is for our children.
Okay.
So that's really important. If you have a special needs child, just perfect protection so that those funds are not a way to disqualify them from benefits, whether a child or an adult, should you pass away. That's very important. And we can get into some other particular situations. I always think of those that are business owners or landholders that want to think about succession planning and as well.
We say landholders, we're not talking thousands of acres. We're not talking the Western Kansas farmer with half a state, right? We're talking even my house. right?
Right, exactly. Your house in particular, like should your kids or your spouse remain in your house, especially in a remarried situation?
And
you know,
remarriage happens a lot in this day.
Absolutely. And that's something I think our firm recognizes is families just come in all shapes and sizes, and we embrace that
Yes.
at our firm. And so it's really important for us to do our estate planning in a way that matches what the intent of the family is. And every family is different. In a trust document, we can be very particular or creative. Vacations are important to my family. We like to travel together. So we've allocated some in our trust to hold in trust for our adult children to vacation or spend holidays together instead of, if my husband and I should pass away, just distributing it all to our children and of our choice.
Gotcha.
I might also add, if your favorite loved ones are pets, we can include pet trust as well. So we've got something for everything: charities, kids, pets, and friends.
Well, and you've said a word that I think is really important, trust. I've heard a lot about the term, you probably have too. Friends, trust fund baby. Who hasn't heard the term trust fund baby?
Yes.
Now, so of course, when you hear that, people, me included at one point in my life, thought, oh, that must mean I need to have a lot of money in order to have a trust. Tell us why that's not accurate.
Yeah, absolutely not. The first thing I tell clients is it's not how much you have, it's what you want to do with it. And
that's a good way to put it.
Let's talk about it in this way. If you want an easy transfer situation, should I be living and later unable to make my decisions, and I want to trust Gabriela or my daughter or my spouse, to make those decisions for me, that person becomes my trustee. And there's not a court required to oversee that. Now, trust is a key word. You always want to pick somebody that you can trust, but it is sort of nice to defray the expenses of court hearings that might be necessary to declare someone incompetent in order to make their decisions, as well as, just the connotation that comes with incompetent as we age, right? So I can speak to family situations I've been involved with that have worked out really well. Parents age, they, beginning even at the young age of maybe 60, 65.
60's not old.
No, not at all. They put their children on as co-trustees. They say, you can stand back. You don't need to do anything. You do need to make sure you can trust them because, they have the ability to do, make changes with your accounts and so forth. But if you trust them, you just make them your co-trustees. As you're no longer able to make those decisions, you let them run with it. And they provide for you as you and your spouse or you individually age. And then upon your death, they just keep going and they follow your directions that you put in your trust. So if it's, provide for my spouse while my spouse is living, and then equally to my children or to the charities of my choice in these percentages, or so much to, my pet caretaker for as long as my pet lives. There's so many variations. And the nice thing about the trust is we've got it all in one place. And we can also say if any of those people that we want to take care of are in the middle of a bankruptcy or a divorce, or they have judgment creditors, or they're abusing alcohol and drugs where we don't want them per se to receive a blank check, then we can say to the trustee, you can pay bills on their behalf, you can provide on their behalf without just turning funds over in a way that would only go to third parties that we don't want to benefit, like creditors.
Or the drug dealer.
Yeah.
I mean, unfortunately, that is something that happens. And so you can still find ways, from what you're saying, to protect your kids despite whatever emotional issues they're having, or your loved ones from problems that they're facing.
Right. But even us, I think we're pretty level-headed women, pretty independent women who come to work on a regular basis. Yeah. And so we'd like to think that we wouldn't find ourselves in that situation. But illness happens in a family. family. It's happened in my own, and we don't always know what the future holds and what that might do to our own accounts. So these funds are protected from all of those creditors. But also, if none of that happened and we kept it our share in the trust, and we needed to pay for our long-term care, but we didn't have enough to pay for the nursing home forever, this would be protected for us in a way that we could still qualify for canned care through the state of Kansas, because our parent or whoever it is that gave us these funds didn't have to. So the fact that they did, they're allowed to put strings attached. And the string can be, if somebody else can pay for your long-term care, have them do that, and this will just supplement it.
Oh, okay.
Okay.
And so that's under like trust models, right? There are other examples of ways to do estate planning. What are some other ways to do estate planning?
The one we all think of is the will.
Yep.
And the will works well, but it does always, 100% of the time in every single state, require the probate court's involvement if assets are passing through a will. And I just kind of emphasize that because so many times I've had clients come in and say, I need to do a will. And I'll say, and you're comfortable with probate court? I'll say, no, I want to do a will to avoid probate court. Well, that's not the way that works.
There's a confusion about what probate and wills are.
Yes, exactly. So if you do a will, it just says whatever I own at the end of my life, here are my instructions. But in order for those instructions to be followed, we must have someone appointed by the court, an inventory taken, publish notice to creditors, even if we don't think there are any creditors, wait a statutory amount of time, and then we can do the distribution. So in the long run, it's often more expensive than doing a trust. You're just deferring the expense until after your passing.
I see what you're saying.
Yeah, exactly. So there are times when it's helpful. I like to lean towards the trust because it's self-administered. We can be far more descriptive, but it is a good stopgap. If you're not sure, what you want to do, you can at least in that will define who your guardian and conservator for your children should be, and you can have something in place. Now, short of that, the other thing you can do is list your beneficiaries on accounts. You can do a transfer on death deed for your real property. You can do a transfer on title on your car. So those all seem like good options unless, your kids are 5 and 10. And you don't necessarily want them to have it at 18, or your kids are 20 and you don't want them to have it at 20, those things. And it also isn't the easiest way through beneficiaries to handle charitable situations because your interests change and then you have to retitle. So we talk about using community foundations, and here in Manhattan, we have a great Manhattan Community Foundation that can be helpful, but those are the ways we customize in our office. Yeah.
And other than wills and trusts, what other types of estate planning are optional for us?
Right. So I would say my philosophy and the way I explain it is when I go and take my car to a shop, I want them to tell me what I need to have in the most affordable way to have it that'll last a long time, right? I'm kind of expecting them to tell me if I go in for squeaky brakes that I have hoses disconnected, or I better make a decision on my transmission too, right?
Yes.
So that's the way I look at it. And part of that for me is taking care of the health as well. So a power of attorney for healthcare decisions is something we want to make sure is in place. And along those lines is whether a person wants a living will. So a living will, unlike a regular will, says if I cannot make my decisions at the time that any of these things occur, here is what I want to happen. And then the power of attorney will be the backup if it's not something you specifically state in the living will. So if you say, if two doctors say that my dying is just being prolonged by life support, and I wish to be permitted to die naturally with maybe hydration and medication to keep me comfortable, I can say that in a living will.
Okay.
If I don't, then my power of attorney will be able to make that decision.
Okay.
If I don't have a power of attorney and it's not clear who my next of kin is, then a hospital is going to ask for a guardian to be appointed, and that's a court proceeding.
Okay.
So always cheaper to do the healthcare, power of attorney, and living will. In our office, we handle some things that you won't find just in a standard hospital form, because the hospital doesn't have someone to go over those options.
Right.
We also have a religious-based form for those of the Catholic religion that is in tune with the beliefs of the Catholic Church. So
Okay.
we customize. One thing we like to discuss right away is if I am in a situation where I don't know my friends and family and I can't take care of myself and there's no expectation that's going to change, then I don't want to be resuscitated.
Right.
Or I don't want surgery unless it's to keep me comfortable. I may not want ventilator. So those are really personal decisions. But in my experience, what families who have lost a loved one come in and are most upset or distraught about is those end of life decisions, and that they didn't know how someone felt or who got the land in the family. Those are the two that are the most problematic for families.
I can understand that. Thank you to Mark Kent, who sent us an excellent question.
Hi, Mark.
Hi, Mark. He says, Lisa, when do you recommend people set up a living will? Is there an age requirement? I think that's a great question, because I was actually just thinking about that. When you're young, you feel invincible, right?
You do, and you always assume somebody will be right there to make your decisions, right? But we all travel with the people that we love the most, and so in a car accident or a plane accident situation, they might not be available. For my own children, who are all adults now, they did a power of attorney for healthcare as soon as they turned 18, and by 20 and 21, we're talking about living wills.
Oh, wow.
Sometimes they elect to say, I have no idea. Mom and dad, make the best decision you can. And sometimes they very much have a feeling as to what they would want or not want. So I think it's a good discussion.
Cool.
Yeah. When I do estate planning with couples, I often say, how would you feel about discussing this with your adult children? And if you would like for them to pursue that, we definitely can help them out as well.
Absolutely.
Yeah.
Absolutely. Well, Mark, thank you. That was an excellent question for sure. Now, one thing that I think is happening in our society right now is that a lot of us have aging parents, right?
Right.
And our aging parents are facing increasingly unique situations, I think, more so than in years past. How can we help our parents or older family members with health or future planning? Some of the things that you described would be things that I think I would want to reach out to my parents about.
Right, absolutely. You know, the name of the game is easy transition, because it's hard to lose our independence. Yes. And sometimes we don't always know when we're not able to make those decisions anymore, right? It's a continuum. It's not today I shouldn't be making them, but it's maybe I shouldn't use my credit card online. Then maybe I shouldn't be writing checks, and then maybe I shouldn't make my decisions, those kinds of things. At least that's been my personal experience as well. So I think that the best planning is continuum planning as well. I think in your 30s, and that might seem young, or late 20s even, it's just a bare bones trust or a bare bones will. So we're making sure that we've got beneficiaries on everything, and that's been thought out. But as we start to add our assets, we start to continuum plan. And if our parents haven't talked to us about it in their 50s and 60s, I think it's time for a conversation, as hard as that is. And I know firsthand that can be. I think it's also ripe to discuss long-term care planning, because we're all prideful, and we hate to admit if we haven't maybe saved enough or have access to long-term care insurance to pay for nursing home or in-home care. Yes. And the reason I think that's important is there are options, and up to 80% of people that are in the nursing home do rely on the state funds called Can Care to pay those expenses at this point in time. And that's just because nursing home care is much more expensive than anyone could have planned for during their working years, as good a savers as they might be, and people are living longer.
Yes.
So the important thing to know about that is if there is a family business or family farm or something that the family really, really wants to keep in the family, they have to be doing that planning 5 years, 60 months before someone might need to qualify for Can Care. And we can help them do that adequately. Otherwise, the only option is to move that asset at the full price at that point in time. And, so often we've had the next generation's been helping on the farm, been working on the farm, and expect to inherit the farm, and then cannot unless they're taking care of the parent in their own home because the parent just doesn't have the funds to pay for long-term care otherwise. So if you find yourself in that situation, come see us. We're really accustomed to working with families and working with succession planning, and I think we can make it easier for you often.
Absolutely. And one thing that just struck me is that by being able to talk to you who has estate planning experience and business law experience, you can bring your expertise from both of these worlds for those small business owners that are wanting to pass on the company to their family, or for that farmer that wants to make sure that that asset that has been in the family for hundreds of years stays for another 100 years.
Right. Even strategies of how to treat the children equally when they're not putting forth equal work in the farm, or
thought about that.
Some are out of state, they haven't been back for years, or at least not to help on the farm. How do I treat the one that's keeping the farm going when I'm no longer able to, versus those that haven't? So we have lots of creative ways that we can work through that, or the business, just as well. Or how do I treat the child who is going to be my primary caretaker and has defined that I'll, move in with them, or they'll make sure everything's taken care of. So we have lots of ways to deal with that. The other thing is with blended families.
From a blended family.
Lots of creative ways. So many times we have blended families, and we're trying to take care of spouse, and we're trying to take care of kids from a prior relationship or marriage. Sometimes we have kids that are in my own family. It's not a blended family, but we had kids 10 years apart. So, if our trust were to say at the time of our death, divide everything equally, and one was 25 and one was 15, that really isn't equal, right? Because the 25-year-old would have already had maybe college paid for, or at least high school health care taken care of. So I think it's really important that we don't rush into a super simple will without thinking about what those consequences might mean.
Absolutely. Well, that makes perfect sense for me. Now, you also brought up the term long-term care. And I think this is something that's relevant. What are some things that we need to be specifically talking about, whether it be with our aging parents or with our own needs? Because long-term care isn't something that you get when you're in your 90s. If you succumb to an illness, you might need long-term care, correct? Am I correct?
Correct, absolutely. So we're really talking about who takes care of me when I can't take care of myself. Right? And there are long-term care insurance policies that, if they're affordable to you, you should definitely evaluate. And those are changing all the time. There are life insurance policies that say if you find yourself in a terminal situation or after a certain age, in a declining situation, you can borrow against the policy, or you can receive the proceeds of the policy over an incremental payout. So we've got some options that, at least when you're buying those products, you should take a look at. The other thing is just, to really make an assessment of what your assets are. And I'm going to say, if your assets at the time you think you need someone to take care of you are less than $400,000, we really need to be thinking about what it looks like for CanCare to step in and help. And we can go over those thresholds with you. But so many times, and I understand it, we all want to think we can take care of everything on our own, right? So many times the first spouse gets ill and the other spouse takes care of them and uses the own assets almost to depletion, when really a division of assets can be done that saves assets for the second spouse for when they need care.
That's smart.
Yeah, that allows them to remain independent. Otherwise, if we use all of our assets or do a reverse mortgage just to take care of the first one, the second one really doesn't have any planning opportunities.
Right.
So important, if you find yourself in that situation, continue to do a checkup. Especially if it's a disease that the progression looks like it will head that direction. It's good to just come in and we visit about what those options are, so you and even your children know them and can plan for them in enough time to really take advantage of all your opportunities.
Absolutely. Well, that answer just brought up even things that I hadn't thought about, like the idea that that you do in a couple's situation, when one of them gets sick, it seems very ordinary that you would start just pushing everything that you could to try to help that person. But then years later, the second person is left with nothing for their protection. So.
And it doesn't mean the first spouse will go without. They'll be taken care of.
Right.
It's just that at some point the state will pitch in to keep the viability for the second spouse. And I want to speak on something that I've noticed happens frequently along the same lines in my practice. I have had people come to me and said, we signed a prenuptial agreement. It says what's mine's mine, what's his is his. And, maybe they signed it when they were 40, 30, whatever.
Right.
That will not trump the rules for CanCare or Medicaid in any state. Medicaid trumps. So if you signed what's mine's mine, what's yours is yours, but you're married, you're still on the hook to participate in that person's long-term care cost. So, it's important for you to know that. It might make it even more important to buy a long-term care policy for that spouse if you're trying to protect most of your estate or land or so forth for the kids, because there are some rules about that and what that long-term care policy can provide for over a period of years that can offset what your obligation is. We can walk you through those things. But I'm not saying don't get married again. I'm just saying understand what those responsibilities are, because they often, really take people by surprise.
Well, that's true. And a prenuptial agreement is only for the event of divorce and how we're going to split up assets in that potential event. It does nothing, from what you're saying, to protect you with medical emergencies or future planning.
It can say what should be in your estate planning documents at death, but it does not foreclose the responsibility to provide long-term care.
Okay.
Yep.
So I feel, have covered so much today, and we have given a lot of really good information. What steps, after hearing all this great information that we've talked about today, should someone take if they want to start working on their estate plan?
Well, we love that. And there's nothing better than to do it at year end or the first of the year, so you can go into next year feeling like you're protected. It's one of those things that you just don't even think about once it's done. So what we've done is created an estate planning worksheet. It's pretty comprehensive. Some will apply to you, some won't, but it's better that we ask than we guess.
Right.
And if you would like to be clients of Adair Thurston, we can send you out that estate planning worksheet. You can have a 30-minute consultation. You can decide if you like us, and we can decide if we like you, and I'm sure we will. And then we can get started. And we do both flat rate estate planning, so this is what I'm going to pay, or we do hourly, and we just define that up front, and that's your choice.
And how do you decide which is the best for that person? Just to give people an idea of what you're looking at.
Right. So somebody absolutely knows, cut and dried, what they want. They've done estate planning before. Their assets are pretty well titled into a trust already, but they just have some tweaks. Hourly is probably the way to go.
Okay.
It's probably less expensive for them. If they think there's a lot for me to learn, and I don't want to worry about every time I call being nickeled and dimed, then the flat rate just makes you feel like you've got it taken care of. We're happy to work. I have an excellent paralegal that assists too. So she's available sometimes when I'm with other clients, but has been with me a long time and is very knowledgeable and works in tandem with my practice.
Absolutely. And would there be any recommendation about paperwork that they should gather in advance of the first appointment, or is that something that can happen as later appointments come in? Which do you think is best for you?
Thank you for that question. I wouldn't keep it from coming in and visiting for sure. The worksheet will cause you to find those documents if you haven't.
Okay.
And sometimes people think, well, I can't find my deed, and if I don't find my deed, that we can call the county for a deed. So absolutely, we are pretty accustomed to working through most assets. Digital assets is something you might not have thought about protecting.
I had never thought about digital assets. We need to talk about those.
Digital assets, a lot of people have great wealth in what they're doing online, whether it be, fantasy games or things of that sort, whether it be Bitcoin, whether it be their Venmo accounts. So we want to make sure that all of that is taken care of and protected, and that we visit with you about it as you do your estate planning.
Estate planning, you would think, never changes because of the things, land, but
yes,
digital assets. Who would think
changing.
Digital assets?
Yep, gun trust, oftentimes people want to leave collectors' guns to their children, but maybe their children have, an old arrest that makes them unable to own guns. And so we can help them if an expungement or something like that's appropriate.
We talked about expungements last month.
Yes.
Sonia, thank you so much for your question. Yes, this is being recorded to listen to again, and we will be posting it at the end of this program onto our Facebook Live, onto Gabriela Vega, Coastal Lawyer Facebook page. So yes, we are excited to be able to provide everyone this information so that they can review it at a later date.
Gabriela, can I ask you a question?
Yes.
Do you know what would happen if your spouse did have a will that maybe didn't name you in it?
Oh, goodness. I couldn't kill him, clearly, because I'm not in the will.
But I think it's
that is a good question.
Yeah.
What happens?
So the first thing we're going to look at is if you properly consented to that will.
Okay.
And so if you did not properly consent to the will, the state does have a way you can elect against it.
Oh,
and we want to make sure that you get what you're entitled to. Oddly, that happens more than one might think.
I believe that.
Yeah. So as things happen in our families or with our friends, that's just a good question to, venture into if you're willing to discuss that with a friend or send them to us to discuss.
Absolutely. Now, since you brought this up, now I have a question.
Yeah.
Would it be the same if there was a trust that didn't name me? Could I use the laws of probate to force the same type of situation?
Yes, you can.
Okay.
But if it's named in the trust, then there's just some hiccups that we have to work through.
Okay.
But I might just share with you. So if the decedent, that's the person that passed away, and the spouse were married to each other for less than a year, then they just receive a statutory amount, which is really like $50,000 and some clothing and so forth allowance. But if they are married, for instance, for let's pick 10 years, then they would receive 30% of the augmented estate. And so that's where we get into not just what passes through the will, but the whole estate of that person with their name. And if it's 15 years or more, then it's 50% of the augmented estate. So I bring that up even if you're the spouse that thinks you want to, leave your spouse out and might get away with it. We might want to plan a little bit differently for that.
That's a good point.
Yeah.
That's a good point. You guys, thank you all so much for tuning in today. We are so glad to be able to share this wonderful, vast knowledge that Lisa has. Smartest lady I know, I promise.
Just old.
No, not at all. We look forward to talking to you guys in the future. Please continue to send your questions. We will be continue to do these types of programs. And next year, I'm sure we will have a lot of new questions to give Lisa, throw at Lisa, so that she can help us with our estate planning and help you with your estate planning. Thank you guys so much. I do want to tell you next week is another Facebook Live program with my beautiful friend Lisa. I am so excited about next week's topic because it's a business law topic and it's a very important one. Year-end planning for your company. So all those business owners, friends that own businesses, friends that have friends who own businesses, you've got to be here and listen to what Lisa has to say.
I'm happy to provide that. We love working with our clients.
I'm going to ask you a question as a small preview. Our program will be November 27th. Do we still have time in 2019 to do some year-end planning?
We absolutely do. Absolutely.
So tune in, you guys. We'll see you next week. Bye.
Bye. Thank you.